There's been lots of requests to talk about the Lucy Letby trial and lots of questions in regard to that, many of which have come about through her recent decision expressed through her barrister not to attend her own sentencing. Some of the other questions about whether a defendant has to attend a trial, whether they have to give evidence, what happens if they don't attend or refuse to attend or refuse to give evidence, and indeed whether they refuse to attend the sentencing hearing. There's quite a lot to this, but if you want the condensed version, make sure you watch all of this one, but I will link to the condensed version over on The Art of Law by our learned friend Alan Robertshaw. I will link to that in the description below. But in the meantime, please stay tuned. Welcome back to the channel. So once again, the CPS website provides a very nicely condensed and descriptive version. Much of this information is available online for you to look at in various sources. It's not just through legal texts, but do bear in mind if you are at a law school and you're on a law course, do stick to the texts. They will certainly be up to date. Let's take a look at this page on the CPS website. I will also link to this in the description below. Now, first of all, there's a distinction to be made between summary-only offences and either way and or indictable-only offences. An either way offence is one which can be tried summarily, i.e. in the magistrate's court, or it could be tried in the Crown Court. Indictable only is in the Crown Court only, and summary only is in the magistrate's only. There's a subtle distinction, although the court will proceed broadly in the same way. There are some subtle distinctions to be made because of the seriousness of the offence. So, as it starts out by saying, there are lots of reasons why a defendant may refuse to attend court, either for the trial, for the giving their own evidence, or for the sentencing, and so on. And in each case, the starting point is that the court will try to find out why the defendant is not or is refusing to attend court. There may be a good reason, which requires further investigation and consideration. Typically, illness is one of the common ones that they might not be attending court, in which case the court may well try to establish a video link. There may be another reason, and we've had cases before now where they just haven't been able to attend because they are far away, the transport wasn't there, they were not able to produce them in court because of travel distance, no cells available, all of those kind of things. So there's a lot of guidance around this area to bear that in mind. But when a defendant such as Letby in this case has already indicated that she's not going to attend, it's going to be her choice. There's no right as such not to attend. There is a right to attend. There is a right to attend the trial. There's a right to give evidence. There's a right to attend the sentencing. There's not a right as such, as far as I'm aware. Criminal specialists may correct me if I'm wrong, but I don't think there's a right as such not to attend. Rather, if it's flat out refusal, whilst the court could order that they attend, that's probably not going to be very productive. So the court will look first of all at the circumstances of non-attendance, the reasons, any reasons communicated for non-attendance, whether the defendant knows about the concerns of the court and what the court hearing is about, whether it is venue is where it's going to be heard, whether it's bail, that's obviously usually quite important to a defendant, whether they get bail or whether they are remanded into custody, all sorts of other issues that the hearings might be about, and of course the trial, and of course the sentence. Now, the important thing is whether or not the defendant knows that the case may proceed in their absence, because that is, if there is a flat-out refusal to attend, that is the ultimate likelihood of the outcome, is that the court's going to proceed in their absence. Now, you'll see in a minute that the starting point is that the court should not ordinarily proceed in their absence, but ultimately will if there's nothing else that can be done. And so, as you can see, there's a subtle difference between summary-only offences here set out and indictable offences, which we'll see further down. But let's go straight down to either way and indictable offences. If the defendant refuses to attend and is not legally represented, an adjournment should be sought. An adjournment just means putting it off until a later date. And these are for first hearings in the Magistrates' Court. Arrangements to be made for an effective hearing and so on. Plea and trial preparation hearing and trial in the Crown Court. The plea and trial preparation hearing is when a formal plea will be entered, if in the case of indictable only, or where it's been sent for the plea. And as you can see, the discretion to start or even continue with the trial in the defendant's absence is one to be exercised with great caution and with regard to the fairness of the overall proceedings. But ultimately, if the defendant flat out refuses to attend, then the court will ultimately proceed in their absence. Moving down to sentence. The court may proceed to sentence a defendant in absence unless these rules apply, which state that the court must not sentence the defendant to imprisonment or detention unless the defendant is legally represented, the defendant's been sentenced to imprisonment or detention on a previous occasion in the UK, or a defendant could have been represented under legal aid but isn't, because this section applies, which I won't go into here. And so there are some rules to skip through, but the bottom line is, if a defendant absolutely flat out refuses to attend the hearings, the trial, the sentencing, the court will most likely ultimately proceed in their absence. Now, as Al said in his video, there is talk of making mandatory requirements for defendants to come into court, but that has its own implications as well. And with regard to trial, lots of questions were asked about that as well, whether a defendant is required to give evidence. The simple answer is no. Whilst a defendant has a right to challenge allegations and the charges against them, they are not obliged to give evidence. Although if any of these things are to be taken against the defendant, such as defendant doesn't turn up for a hearing, doesn't turn up for trial, doesn't give evidence, doesn't turn up for sentencing, each of those may create an adverse inference which can be taken against the defendant. So in terms of trial, it will be suggested by the prosecutor that the lack of evidence may imply guilt and can be drawn against the defendant. Although they can't be convicted solely on an adverse inference, it's quite likely to be something taken seriously. It's a little bit like the police caution, where they are not compelled to say anything, but anything they do say will be given in evidence. And if they rely on something in court that they haven't mentioned when questioned, again, that's going to lead to an adverse inference. That's the whole purpose of the caution, to give them the warning beforehand that if they don't mention it earlier and they then mention it in court, it can be taken against them. And again, an adverse inference can be drawn. But the same is true if they say absolutely nothing. If they refuse to give evidence, they don't give evidence, that can lead to an adverse inference. Much like not attending the sentencing hearing, the judge can take that against the defendant when considering sentence because they have yet further failed to cooperate, shown further disrespect, and so on. So there is quite a lot to this. I will link this guidance in the description below. And as I say, one or two points that I have not trodden on from our learned friend Alan Robert Shaw, linked in the description below. Go and check that out. In the meantime, please do make sure you like the video if you found that interesting and subscribe. And as always, thank you for watching.